Welcome to another episode of Cátedra Jurídica, where we engage with leading minds shaping the landscape of law and society. I'm your host, André Oliano, and today we have the distinct honor of welcoming Professor Adrian Vermeule. I confess that I've been waiting for this interview. One of the most influential legal scholars of our time. This program, presented by Gazeta do Povo newspaper, offers deep dives into the ideas and contributions of prominent authors, exploring their impact on law, governance, and society. Our guest today, Professor Vermeule, currently holds the prestigious Heath-Tyler Professorship of Constitutional Law at Harvard Law School. A renowned expert in constitutional and administrative law, his groundbreaking work on common good constitutionalism has sparked wide-ranging discussions in legal and academic circles. Educated at Harvard College and Harvard Law School, where he graduated with highest honors, Professor Vermeule has an illustrious career, including clerking for Justice Antonin Scalia on the U.S. Supreme Court. In this episode, we will explore his theory of common good constitutionalism, a vision for constitutional interpretation in constitutional law and legal theory in general that moves beyond the classical liberal framework to emphasize the role of law in promoting the common good. This theory has captured the attention of legal scholars and policymakers alike, challenging traditional constitutional theories and offering a robust alternative in our times. Professor Vermeule, thank you so much for joining us on Cátedra Jurídica. It's such a pleasure to have you here today to discuss your remarkable work.
Thank you so much. It's a great pleasure to be with you and to have a conversation and hopefully learn something about Brazilian jurisprudence, which is much on my mind lately.
Perfect, great. So first of all, Professor, I'm still warming up my spoken English. So if you do not understand anything, please just let me know, and then I will try to rephrase or try to speak clearly. Okay?
Great. Thank you, Andre.
Okay. So to kick off our conversation, Professor Vermeule, could you share with us the key moments in your academic and professional journey that led you to develop the concept of common good constitutionalism? Actually, what motivated you to depart from more conventional frameworks and eventually articulate these ideas in your book?
Well, so I've never been a legal formalist in the American sense. And as I worked in public law, constitutional and administrative law, I started to develop the view that judges and other interpreters of the law were inevitably and necessarily working with some conception of the human good in society, the common good. Sometimes they weren't even aware that they were doing so. Sometimes it was articulate, sometimes it was inarticulate, sometimes it was expressed, sometimes it was implied. But it seemed to me that even without knowing it, they were always assuming some conception or other of the end of law, the teleology of law, that it was promoting some version of the public interest or the common good. For example, when judges would read statutes, they would approach them with presumptions that trace their roots right back to the origins of the classical Western law. For example, they would presume that statutes were enacted in the public interest for some public regarding end. They would never just assume that, or they wouldn't even be agnostic about the possibility that the statute could be a joke or that it could be self-interested on the part of the legislators or something. They would always attribute to it some public regarding end. So it seemed to me that in the fields in which I was working, law was inevitably and necessarily teleological. And James Joyce says somewhere that you discern the universal in the particular. So the deeper I got to the bottom of Anglo-American public law, the more it seemed to me that this was a universal phenomenon, and then I could see it in other domains of law as well. So that's why I started uh, writing in this vein. I've been doing it for a while before this most recent book, Common Good Constitutionalism. So I really see Common Good Constitutionalism as a third in a trio of books. The first being called Law's Abnegation, the second being called Law and Leviathan, and then Common Good Constitutionalism. And Law's Abnegation, one has to understand that the title of that book refers to law in the sense of lex, not in the sense of use. So the essential thesis of that book is that the positive law cannot fully account for the constitutional and administrative law of the public state in Anglo-American law today. And Law and Leviathan looks at the flip side of that argument and says that what does account for the fundamental principles of the public state in Anglo-American law are unwritten principles of use that have classical origins, and they're no part of our positive law in the sense you can't look at a code and find them somewhere, but they are fundamental structuring principles for the state and its law. So then, common good constitutionalism just brings these two theses together and makes them explicit and says that the classical law is still very much with us. What's happened is that the judges are unaware, partly, sometimes, unaware that it's with us, that they are like Moliere's character who speaks prose without knowing it. They speak the classical law without knowing it. And common good constitutionalism is an attempt to make that explicit and give our legal interpreters a kind of course of therapy towards self-awareness, if that makes sense.
Perfect. One question. In your article, Interpretation and Institutions, you criticized Dworkin, particularly for his lack of consideration of the practical institutional capabilities of courts and judges. You argued that his approach overlooks the fact that real-world judges may not consistently have the expertise or resource to make morally sound decisions, especially when faced with the cognitive and time limitations that Dworkin's idealized figure of Hercules does not experience. However, in your early pages of your new book, Common Good Constitutionalism, you describe yourself, your method, as Dworkinian in some respects, though you differ in substantive positions. Has your view on Dworkin's approach evolved over time, or is there a way to reconcile these seemingly contrasting perspectives?
It's so interesting. I don't think it has evolved one bit. I'm not a flexible man. When I believe something, I believe something. And I don't think it's changed one bit. And let me explain why, but let me also refer anyone who's interested to there's an article in the recent issue of the American Journal of Jurisprudence by Connor Casey, who discusses the consistency of these views over time. Okay, so what's the explanation? Well, if you look at common good constitutionalism, say, I think quite expressly, that I rely on Dworkin for certain limited propositions. That is, a legal theorist is not like a supermarket. It's not like It's not like you have to go into a supermarket and buy everything or buy nothing. You can buy certain items and not other items, if that analogy makes sense. So
Per-
from Dworkin, I draw certain limited propositions. I think his critique of original American originalism is quite devastating. And I think his account of adjudication, sounding in fit and justification, is basically right. And I agree with John Finnis that Dworkin's account of adjudication is essentially the same account as is present in the natural law tradition, in the classical legal tradition. Finnis says this in one of his works, and I think also in the Stanford Encyclopedia of Philosophy. So those are the things I draw from Dworkin, and that is all entirely consistent with saying that the best account of fit and justification in a particular legal order might not commit to judges, and in my view, in our system, does not commit to judges the task of sort of doing unbounded moral philosophy for themselves. That view might not fit the legal materials, and in my view, it does not fit the legal materials in our system. So in the book, I say that the classical American legal framework, and this is true of, I think, the classical framework generally, is one that commits to um, legitimate political authorities the authority to make determinaciones, determinations, or specifications of background legal principles. And the judge's job is to faithfully interpret those principles and to do what is called an American law kind of arbitrariness review to see whether they are so outside the bounds of natural reason that they cannot be defended as a legitimate determination of background principles. That kind of review, though, is quite deferential, and it doesn't call upon the judge to do moral philosophy. Another way to put it is there's a dictum of Paul Ricoeur that I really like. He says, um, justice is caught between law and the good. It looks both ways. That is, that the judge's task of doing legal justice is simultaneously trying to work with and reconcile both principles of law's inner morality on the one hand, and on the other hand, institutional roles and obligations. So part of the common good is that different institutions have different role morality and different obligations within the system. So it doesn't follow that judges themselves are to decide in an all things considered way what is best. So in that sense, I see no inconsistency with the earlier paper, and I would underscore that I'm not a legal liberal. That is, I believe that it's perfectly possible to have the rule of law without the philosophical commitments of liberalism, and I simply don't think that Dworkin's liberal commitments are uh, essential to the parts of his views that I like. That is, I think his liberal commitments are detachable from the parts of his view that I do use.
Perfect. Professor, I'm curious. Um, did the work of John Finnis somehow started to have a greater impact on your thought in some point of your career, or did you always study his work?
I've always admired Finnis. How could you not? I would say this about John. I think the classical legal tradition has always had two sides, and it's had um, a side that I think of as the natural law tradition per se, which is heavily influenced by philosophy and theology. So I think of in the modern era figures like Heinrich Röllmann, and Finis is very much in this tradition. But it has this other side, which is more civilian. That is, it's more practical, and it's takes its bearings not primarily from philosophy and theology, but from Roman law and from the jus commune of Christendom. And I thought that as much as I admire Finis's work, that this other side of the tradition had been somewhat undeveloped, and that it was time someone brought that other side of the tradition to bear on public law in our era. So that is the sense in which I both learn from, but also want to broaden or complement what Finis does.
Perfect. Okay. In the third chapter of your book, you attempt to define the concept of common good. Why do you believe this foundational idea is relevant for jurists, especially in their often more pragmatic and trivial, I can say, role within the administration of justice? Additionally, how would you explain the concept of the common good in this context?
Good. Thank you. So, that's an extremely rich question. So, pardon me if I'm a bit long-winded. But let me give a preliminary and then let me define the common good for legal purposes. One of the emphases of the book is that the common good is not to be seen, at least not solely, as a philosophical concept or a theological concept. It is a working legal concept. That is, it's a concept that is ubiquitous within legal systems. So, if one looks at constitutional provisions around the world, beginning with both the U.S. Federal, that is, National Constitution of 1789, and the Polish Constitution of 1791, and indeed the Constitution of the State of Massachusetts from 1780, which I'm very proud of because that's my state. If you look at these very early written instruments, they all are expressly say in preambles or opening provisions that the orientation of the Constitution is to the common good or the general welfare. And this is written right into the law itself. And the interpreter has to do something with that. That is, it's already a concept within the law. It can't be ignored. The interpreter has to find some way of treating it as law. Um, and it doesn't mean, again, that the interpreter has to decide in a freestanding way what counts as the common good. It may be that the common good includes role morality and includes the authority to make determinations on the part of political authorities and so forth. But what it does mean is that the interpreter can't simply throw up his or her hands and say, who decides? The common good is indeterminate. That is because the lawyer or judge is not in an academic seminar. They can't just say, let the discussion go on. We need more and more exploration of the nuances of the common good. It has to be made a practical, working legal concept. And this, too, goes right back to the beginning of the origins of Western law. So in the digest, Papinian says that the fundamental criterion for the validity of the jus honorarium, the doctrine made by the urban praetor, is utilitatem publicum, the public benefit or public utility. And a lot of the corpus juris is working out in specific contexts what that means. So if cargo is lost from a ship that's been in a storm, who should bear the loss? Well, the digest discusses this in terms of the public interest. Where should the loss fall in the public interest, and so forth. So the jurists are constantly trying to make the common good a practical, working legal concept, and it is not something that can be simply put off the table if one likes. Uh, so that's all the preliminary point. The substantive point is, what is the common good? Let me start with something that Marcus Aurelius says. He says, what injures the hive injures the bee. So what injures the beehive injures the individual bee as well. So Marcus Aurelius's point is that the highest good, the highest temporal good, I should say, even for individuals in the secular order, is living in a well-functioning, flourishing polis, a community that functions well. What does it mean to function well? Well, the tradition makes this more and more specific and works it out. So we have Ulpian's famous trio of the precepts of legal justice. Um, Let me uh, read them out, if I may.
Of course.
Yeah. Okay. Um, I can't find it now, but they go, Juris praeceptus sunt haec honeste vivere alterum non laedere sum quique tribuere. That's from memory. I think that's right. So the idea is that there are three fundamental precepts of legal justice that uh, um, contribute to and constitute a just and flourishing political community. They're to live in good faith, honeste vivere, alterum non laedere, not to hurt others, not to injure others. And third, to render each person their due in justice. And I would say that Ulpian's formulation is incredibly impressive because if you just take any one of those without the others, you get a deficient or defective account of what it means to live in a flourishing political community. For example, if you only take alterum non laedere, don't harm others, you get a kind of Anglo-American liberalism of the sort that John Stuart Mill defended, which is freedom subject only to a harm constraint, subject only to the constraint that we not harm third parties. But that seems a radically deficient account of a common life because it overlooks that um, uh, all our actions affect the whole fabric of the community. They affect its tenor, they affect its norms, they affect what it means to live in common. So I find Ulpian's formulation much richer and more compelling than the impoverished formulations one sees in 19th and 20th century legal theory. Now, what concretely are the goods that a flourishing polity contain? Well, there are things like obviously physical safety, life, health, um, uh, public goods in the economist sense, that is, education, clean public spaces, and environmental spaces, a minimum standard of living for those who are destitute or incapable of providing for themselves, and so on and so forth. But these have to be worked out concretely through the development of law, and that's what the tradition tries to do. Most broadly, I would say the common good isn't a thing, it's an orientation or a disposition. And it's a disposition that's very different than the disposition one sees in liberal legal theory. So the fundamental disposition of liberal legal theory is Unchosen constraints are illegitimate, except insofar as I have participated in the formulation of those constraints through democracy or through some other mechanism. But otherwise, unchosen constraints are heteronymous, not autonomous, and they're illegitimate. And so the idea is to maximize individual freedom subject only to the like liberty of others. The disposition of classical legal theory is entirely different. It says the first thought of those charged with care of the community should be what is best for the community overall? Because what is best for the community overall is also the highest temporal good of individuals. So that orientation of the law.
Perfect. Uh, a doubt that just happened to me now. Uh, do you think that is there any uh, kind of risk that this idea of overall good of the society can bring with it some kind of moralism in terms of a state that want to decide more and more things for the people? I believe this is a common uh, a common doubt that some people raise when they listen about common good and ideas attached to this theoretical framework. What do you think about this kind of criticism?
Yeah, I think you're entirely right to raise this question, and it's a great one. But I think that the content of what you call the doubt is not right, and it rests on a kind of conceptual confusion. So let me explain. The conceptual confusion is between the justification for legal rules and the operative content of legal rules. So the common good is a just type of justification for legal rules, but it doesn't follow that the operative content of legal rules has to be maximally statist or maximally moralistic or oppressive. So Aquinas in his treatise says the common good itself requires that the law should not try to prohibit all vices or promote all virtues. And why does the common good sort of restrain itself in that way? Well, because often by trying to prohibit all vices or mandate all virtues, one ends up doing more harm to the common good than promoting the common good. So if people resist, or if the machinery of enforcement becomes too oppressive, if one has to hire more police to enforce virtue than um, the benefit to the community of enforcing virtue, then the whole enterprise becomes perverse. So the fact
Mhm.
that legal rules are justified on the basis of the common good doesn't necessarily imply anything at all about how statist or authoritarian they may be. They may be quite liberal in the old sense of liberal. That is, they may be quite tolerant and magnanimous, if one likes. But what makes them non-liberal in the modern sense is they're not committed to the view that freeing the individual from all unchosen constraints is the goal of the system. They are committed to the view that the flourishing of the community is the goal of the system.
Great. Okay. In the next chapter, the fourth chapter, you discuss your view of what you call the classical legal tradition. Could you explain what this tradition entails? And moreover, does it have significance beyond the United States? Do you believe that it's feasible to revive this approach in other countries influenced by the Western legal tradition, in some measure at least, such as Brazil? In other words, using here the title of your new article, Brazilians also should enrich legal theory.
Oh, absolutely beyond the United States. In fact, in a certain way, my project is to remind lawyers in the United States that our tradition was originally just a branch of a much broader European tradition, and indeed the legal tradition of Christendom, well beyond Europe, so including the Portuguese and Spanish empires, and the countries that came out of the Portuguese and Spanish empires, which would include Brazil. So the idea is that there was for almost 2 millennia a kind of common framework within which Western law was debated. And this is the classical legal tradition. Of course, there were endless debates within that framework. So debates between emperors and popes, debates over national sovereignty, the debates are endless. But the point is, the debates happened within a common set of legal concepts, a kind of common legal cosmology, if you like, and a common account of legal sources. So in the book, I think it's very striking that if you look at the fundamental account of legal sources in Gaius's Institutes, it is essentially the same account of legal sources that one sees in Blackstone's commentaries. And these are two books separated by almost 2,000 years. And the latter book, Blackstone's Commentaries, is the foundation of American of United States legal thinking. So, but these books, separated by almost 2,000 years, both have a common legal cosmology. So they think that there is the positive or municipal law of a particular jurisdiction, the jus civile, but then they think there is natural law, there's the jus gentium, or natural principles of international law, if you like. They think there is divine law, the jus divinum. And the task of the classical lawyer is to harmonize, if you like, these sources of law. And the consequence is that, as Gaius says, and as Blackstone says too, law has both a general part and a particular part. Of course, the law of Brazil will be adapted to Brazil's particular history and traditions and conditions. But Brazil and the United States and France and every other country will participate also in a general framework of the jus gentium and of the jus naturale, the natural law, in which there are common legal principles or general legal principles that transcend any particular system. So that's the sense in which the book is emphatically not about the United States. It's trying to remind lawyers in the United States that there is a general part to the Western legal tradition as well as to a particular part. One way of understanding the turn to legal positivism in the 20th century, at least in the United States, is the idea that the general part of law is lost, the natural law and the jus gentium, and that all law is seen as jus proprium or jus civile, the like particular law of a particular jurisdiction. And if those background principles are not embodied in the particular positive law of a particular jurisdiction, then they don't count as law and they're not seen as binding. And I reject that conception entirely.
Perfect. Okay. In your book, you, after conceptualize common good and the classical legal tradition, you go on to criticize the dominant approach, at least in the US, of positivist originalism and living constitutionalism. Could you briefly summarize your critiques of both? And
Yes.
specifically regarding, oh, can
Please
you,
go
if you
ahead.
want, you
Yeah.
can. Okay. So, specifically regarding originalism, in your earlier works, you defended the idea of presumptive textualism. And I
Hmm.
would like to know if, in constitutional interpretation, if you could summarize your position by a kind of presumptive originalism as well. And if the distinction between your approach and originalism would arise only in exceptional borderline cases, or do you see them diverging even in core interpretive matters?
Good. Thank you. So let me take your first question first. So, to my mind, both what we call in the United States originalism and what we call progressivism are um, two sides of the same coin. And I think this is an argument that has really infuriated some originalist critics in the United States who see themselves fundamentally as locked in a battle with progressives and don't want to think of themselves as um, uh, kind of in the same family as the progressives. But from my standpoint, they are in the same family, both types of legal positivism. That is, both originalism and progressivism fundamentally root law in will, in human will, and reject the idea that there can be legal norms not chosen by human will. So the originalist sees the criterion for something counting as valid law that it have been enacted by the choice of lawmakers at a certain time in the past, say the Constitution makers of 1789 or the ratifiers of the Constitution of 1789. Um, the legal progressive thinks that the criterion for law's validity is that it correspond to um, uh, uh, what people want today, that is democratic um, will formation. And this is why they think that their view is living constitutionalism, because constitutional law can be made today even without formal amendment by the a sufficient consensus of human will at the current time. But both of them, from my standpoint, share the same fundamental philosophical presupposition that law is solely rooted in will. Um, and so, another way to put it, perhaps, as a friend of mine puts it, is that the legal progressive is a valorizes the will substantively, and the legal originalist valorizes the will methodologically, but both are doing variants of the same thing. So I regard the legal debate within the United States as strikingly narrow. That is, it is an intramural debate. It's a debate between siblings, if you like, who each think that the other is radically different than they are, but they're both mistaken.
Mhm.
So that's made me friends on both the originalist side and the progressive side. Um, okay. Your second question about presumptive textualism and presumptive originalism is also an excellent one. I would say this: there there is in the classical legal tradition an attitude that can look like textualism and look like originalism, but it is fundamentally different because it's justified on quite different grounds. That is, um, for the textualist in the United States sense in 2024, Text is rooted in legal positivism. That is, as Justice Gorsuch once said, only the text is the law because that's the only thing that was chosen by the will of the lawmakers. For the classical legal theorist, it is not true that only the text is the law. There is this broader hierarchy of legal sources, some of which are jus civile, some of which are chosen by lawmakers within the system, some of which are unchosen norms of natural law or divine law. And the task of the classical lawyer is to harmonize all these things together. Now, when the classical lawyer goes to interpret statutes, they can end up doing something that looks like textualism because the classical lawyer has every reason within the classical legal framework to afford great respect to the text. And the reason that the classical lawyer affords great respect to the text is that the higher background principles of law establish a role morality that tells us that the legitimate lawmaker in the system is entitled to formulate jus civile for that municipal jurisdiction, so that we are trying to find out what purpose or end the lawmaker had in view by formulating the jus civile, the text. And often the best way to figure that out is to just respect the text on its face, unless there's some special reason to think that the text is indeterminate or in some other way defective. But the justification for that, the ground for respecting text in that classical system is not the same as the positivist ground. So that disposition or attitude affects the whole system, and the classical lawyer thinks that rather than having an antagonistic view of law in which the will of the lawmaker must trump everything else, the classical lawyer has a harmonizing view of law in which the aim is to try to use legal presumptions and other background principles to harmonize jus civile with the natural law, with the jus gentium, and so forth.
Perfect. And this expression, presumptive originalism, does it make sense or no?
Um, yes and no. It does. I would not want to say that if originalism were understood in the positivist sense that it's understood in the United States today. But if we understand originalism in a different way, in the following way, it could make sense. The way it could make sense is if originalism is understood as the following. Given that background legal principles have appointed the legitimate political authority, the right to make the jus civile, we need to know to what ends the authority was making a particular rule of law. That is, we need to understand the teleological thrust of the law that was made. And in that sense, when we do that, we have to understand, for example, what did the lawmaker understand by certain words? So Dworkin, who's no originalist and no positivist, himself says that if we're reading Hamlet and we see the term hawk, we have to understand what that meant for Shakespeare. It doesn't mean a predatory bird that flies around. It means a certain type of tool that was present in Elizabethan England. So in that sense, but only in that sense, we have to be originalists. But the point of doing so is entirely different than in the positivist American version of originalism.
Perfect. And do you think that approach such as of Jeffrey Pojanowski or maybe even Richard Eakins, this kind of originalism, if we use this label for them, um, do you think that your approach and their approach will be very similar in practice, and we will find some collisions just in borderline cases, or even in the core you think your approach will be very different in practical in the way that you will solve practical questions?
Yeah, let me separate out those two figures. Um I get a lot from Richard Eakins. I think he's in substance, if not in self-conception, doing a lot of what a classical lawyer does. That is, he wants to understand the point or end for which the lawmaker made the law, and that is, as I said, um, part of what the classical lawmaker does. Although Eakins, I think, is insufficiently attuned to the uh, method of harmonization that I was discussing, that the classical lawyer
Mhm.
has to harmonize the civil law with the broader set of legal sources present in the tradition. Okay, but I can agree with Eakins quite a bit. I think that Jeff Pojanowski's kind of a sort of attempt to combine originalism with natural law. I don't think it's satisfactory, and
Okay.
I explained why in the book. The fundamental question is, do you think that higher sources of law, for example, natural law, do you think they are binding in their own right, or are they only binding because and insofar as the positive human lawmaker incorporated them into positive civil law? And I believe, I haven't uh, uh, refreshed my recollection on this, and I don't think Jeff has written a full like book explaining his theory of law. But if I
I don't think
understand
so.
him, I think he thinks that for example, natural law is only binding because and insofar as it is incorporated in positive law by the will of the human lawmaker. And that is not consistent with the classical tradition, which thinks that the natural law is binding ipso jure, it's binding of its own force. So, in that sense, the whole conception is fundamentally different. Of course, in particular cases, look, in particular cases, legal theory doesn't matter often. Like if I ask you, if I'm going 80, look, if I'm going 80 miles an hour in a 40-mile an hour uh, zone, you don't need to know what your legal theory is to know that I should get a ticket, right?
I
So
agree.
on the ground, a lot of law is like that. But there always do come cases where legal theory matters, and
Mhm.
that's the sort of situation, call them hard cases, where I don't think Jeff is offering an adequate account of the classical legal tradition. I think he's just a modern positivist who has a kind of a bad conscience about being a modern positivist. But I think it's just modern positivism. Yeah.
Okay, Professor Vermeil, now I'd like to turn to your approach to civil and human rights. You have touched this question already, but maybe we can develop a bit more. So,
Yeah.
many critics express concern that prioritizing the common good could potentially undermine individual rights and liberties. In Brazil, for example, we are seeing stringent, and in my view, deeply unjust restrictions on freedom of speech, often justified by arguments about protecting society from dangerous opinions. Which this kind of argumentation could be interpreted as a defense of the common good against individual liberties. How would you respond this kind of concern that common good might be used to justify similar constraints on individual freedoms?
Good, thank you. I did touch on this before, but let me try to come at it another way. I don't see the situation as one in which the common good is on one side and liberal individual freedoms are on the other, and we have to kind of balance them or trump individual freedoms by the common good. I actually think that is the framework within which liberal legalism understands collective interest. That is, it starts with an individual right justified on the grounds of autonomy and then says, well, in certain cases, that individual right has to be trumped or overcome by collective interests. So, for example, I have a bodily autonomy interest that is overcome by the need for a military draft, for example, in order to protect the nation. That is not how the classical law understands rights. That's actually the liberal framework. The way that classical law understands rights is that the common good is built inside rights from the beginning, so that rights are themselves justified by their contribution to the common good. And for that reason, the classical legal tradition has a very long history of recognizing and championing rights that are attached to individuals, although those rights attached to individuals are justified by their contribution to the welfare of the community as a whole. Let me give a very old example that Richard Helmholtz gives in a paper of his on rights in the Jus Commune, which I heartily recommend to everyone. Helmholtz says one of the oldest rights in the classical Western legal tradition is the right to be heard before a sanction is applied to you. That is, before the state can apply some punishment for you, you have a right to be heard in some way, to give your side of the story, if you like. What is the foundation for that right in the classical legal tradition? Well, one of the earliest accounts of the foundation of that right goes back to the third book of Genesis in the Old Testament. And what classical lawyers would observe is that when Adam and Eve engaged in highly culpable behavior, that is, when they violated the prohibition and ate of the fruit of the tree of knowledge, God comes to them in paradise and asks them what they have done and asks them to explain themselves. Now, presumably, it's not because God needs information. God is omniscient. But what God is respecting is that the dignity of his own human creatures requires that they be allowed to explain themselves or state their justifications or excuses before judgment is passed and before a punishment is applied. So I give this only as an example of a very old example of how classical lawyers operating in an entirely non-liberal framework would nonetheless justify what we would today call individual rights just on other grounds. So that was all one point, that the classical law emphatically does recognize rights attached to individuals. It just justifies them in a different way. let me say something with respect to free speech in particular and its status under liberal legal theory. I think one of the striking things we've seen in recent years is the overriding of free speech rights, but precisely in the name of liberty. That is, liberty is the justification that is often given to override the free speech rights of individuals. So one thinks of Rousseau's comment that on le forcera d'être libre, we will force them to be free. So let me give two examples of this. There was an incident at Stanford Law School where a judge was, eminent federal judge Kyle Duncan was shouted down by a mob of students. What was striking about this incident is that the mob of students who shouted down the judge were themselves appealing to liberal principles. They were a good disciples of John Stuart Mill, and they were claiming that the judge's views were harming them and therefore infringing on their liberty, and that they were engaged in an exercise of free speech by shouting down the judge. Now, we may or may not think that they have the right conception of free speech, but the point is they were not engaged in some kind of outside enterprise. They were arguing within the liberal framework and appealing to the liberal framework precisely to suppress free speech. So that's one example. The other example, I tried to look into the Brazilian situation, and I am going to cite something that may just be a bad translation or may be wrong. So please feel free to inform me if I've gotten it all wrong. But in the order by which um, the Justice Moraes, am I saying that right? Suppressed the Twitter platform in Brazil. This order said, according to the translation we have in the United States, it said the following: that Twitter was violating the free choice of the electorate by spreading misinformation. That is, the principle on at least on this ground by which judge was suppressing misinformation was precisely in the name of freedom. That it was in the name of freedom that we needed to ensure that only approved things could be said. So I would resist the contrast between the liberty of individuals on the one hand and the common good on the other. The liberty of individuals within a liberal legal framework is often appealed to as the very justification for suppressing free speech. So I think it's very much an open question which framework does better at protecting free speech. I will say that there is a view, which I share, that societies that conducted their constitutional affairs under a classical legal framework were often more tolerant in a certain way of uh, individuals and their speech, precisely because they thought that that sort of tolerance contributed to the common good. So I would, in that sense, say to people with this concern that they they might have it all backwards. That is, they should worry that free speech is being suppressed not in spite of legal liberalism, but because of legal liberalism. Oh, Andre, I can't hear you again for some reason.
Okay, perfect.
Oh,
I
there we
have
go. Yeah.
muted my micro. Yes.
Okay. Thank you.
So, can we say that in the classical legal framework, civil rights and liberties are integral part of the common good?
Absolutely, absolutely, exactly. That's what I'm trying to say. They're justified on the grounds of the common good. Now, look, what is true is that the classical legal framework does not think that a right that attaches to individuals justified by the common good is absolutely sacrosanct. But neither does the liberal legal framework. That is, the liberal legal framework always admits some override to autonomy based rights based on what it takes to be the aggregate interests of the community. I don't think that in either framework we can demand a kind of unconditional individual right.
Perfect. Um, so finally, what role do judges play in the framework of common good constitutionalism? Given that the concept of common good is broad and potentially indeterminate, isn't there a risk in allowing judges to base their rulings on such a principle, even if this kind of uh, this attempt to harmonize uh, more concrete legal material with more broad principles, is there a risk here or not, and how can we ensure that this approach doesn't lead to judicial activism or unpredictability, undermining the rule of law?
Good. Thank you. I mean, this is a legitimate question, and I would say that I think it rests on a mistaken assumption. I think it rests not your question. Your question is excellent, but the argument you were simply ventilating rests on a mistaken assumption. And the mistaken assumption is that we start with a baseline case in which the positive law is determinate, and that appealing to other sources of law threatens to render the law indeterminate and therefore unpredictable. I would say a couple things about that. The first is that often the positive law is itself indeterminate. There's more than one semantic meaning to a string of words, for example. And as Dick Helmholtz also observes, sometimes the appeal to background principles, for example, principles of natural law, actually makes the legal system more determinate. That is, it resolves a case in a predictable way that would otherwise require an unpredictable, arbitrary choice by the judge between possible meanings of the positive law. So, for example, suppose we have a statute whose semantic meaning is ambiguous, but one of the readings is in accordance with a unbroken, long-standing background principle of the legal system. So, for example, suppose it's unclear whether the statute does or does not operate retroactively to punish individuals for conduct that they engaged in before the statute was enacted. Well, in that case, appeal to the very old background natural law principle against retroactive legislation. It makes the decision more determinate. It allows us to choose in a predictable way which of the possible readings of the statute is better. So it's just a logical mistake to think that having more legal sources makes the law less determinate. Sometimes it makes the law more determinate and more predictable. That's all one point. The other point is just to reiterate something I said earlier. It's just not the case that under the classical legal framework, the role of the judge is to decide in some kind of unstructured way, what counts as the common good, and therefore engage in a kind of judicial activism of the philosopher on the bench. the common good itself builds in role morality distributed across the system. So it says that the presumptive initial authority to make determinationes of the jus gentium or of the jus naturale is vested in the positive lawmaker. And this is why we have the drafter of the Napoleonic Code, Jean-Marie Etienne Portalis, saying that the lawmaker looks both ways. The lawmaker both makes civil law but interprets the natural law. The lawmaker is engaged in a interpretation and determination of the natural law in making the positive law, and the office of the judge is to respect that in the classical legal framework, not to I don't know, whip out the judge's copy of John Rawls and decide what a better law would be. Okay. Conversely, I think it's actually quite demonstrable that legal positivism and legal liberalism have done a terrible job at constraining judicial activism. That is, legal positivism and legal liberalism have, they encode in the positive law very general legal concepts like liberty that are then appealed to in order to justify wild excesses of judicial activism. And we really do see judges more or less whipping out their copy of Rawls or whatever it is and then enforcing that on the general population. So I find this concern quite puzzling. I want to say, look around you. Do you think that the turn to legal positivism and legal liberalism in the 20th century has done a great job at checking judicial activism? I mean, I don't see it.
Perfect. The rule that you just mentioned from Brazil shows very clearly.
Oh,
Uh,
really?
yes,
Tell me.
this decision about the ban of X,
Oh,
it
yeah.
does not have any positive, concrete, democratic source. It's just like philosophers on the bench, you know?
Interesting.
Yeah.
What provision? I mean, are they appealing to some particular constitutional provision?
No, actually not. Uh,
Oh,
I can't see
interesting.
anything
Yeah.
in the constitution that allow them to do this. Uh, they just appealed for very broad principles, which is very common here in Brazil because of the influence of what they called here new constitutionalism. That it's like a more principle approach than, but inspired by more progressive understand of principles, and they called it progressive. I don't think that it has created any progress, real progress, but
Interesting.
they,
Yeah.
yes, they say that they need to protect democracy, what they understand by it, from opinions that they think they say that could harm democracy, and so they started to, without any legal provision, to shut down entire profiles on social media,
Yeah.
and as the resist to that, they said, okay, so we will shut down the entire platform in Brazil, and not just that, but impose fines on people that try to access it through VPN and this kind of stuff that does not have any kind of legal provision that allows this as well. And for example, I'm now in the United States, so this does not affect me right now, but I love to engage with American scholars, legal scholars, and they, in general, post on Twitter. So it will
Mm.
harm my legal scholarship. It's devastating, and it affects millions of people without provision. So I believe that this shows how this more, they call it
Yeah. Yeah.
liberal,
Yeah.
can cause.
Well, Well, happily, I can report that that would emphatically not be uh, allowed under the classical framework of judicial review I lay out in the book. And and let me semi tongue in cheek recommend also Substack as another platform where I think there's a lot of good legal discussion to be had. But that's really interesting. Thank you.
Perfect. So, Professor Vermeer, lastly, for students, academics, professors, or practitioners who wish to deepen their understanding of legal theory, what key readings or resources would you recommend? And furthermore, what general advice would you offer for those looking to enrich their approach to law, whether in research, teaching, or practice?
Good. Thank you. That it's a great question. So uh if you don't mind, let me mention two sites that have been extremely active in classical legal theory lately and are just very rich in resources. One is called Use at Justitium, and on that site there is a what's called an introductory reading list for the classical lawyer, and it contains sources from Roman law, from canon law, from um, uh, uh, you know works post 1789 that um, uh, apply the classical law, and that might be a helpful place to start. The other site is the I think the leading forum now for classical legal theory is called the New Digest, and on that site, of which I'm a co-editor, there are a number of reading lists for people interested in classical law, and there's many posts where people say, here's an example of a case, and here's how to think about it from a classical legal perspective. So that may be helpful for the practitioner. I mean, my general orientation is to read law from before World War II. Basically, that is, uh, it, I think that it's very striking, at least in the United States. I suspect very much it's also true in Brazil because I know how profoundly learned the Latin American lawyers of the 19th and early 20th centuries were. There's a trove of classical legal learning that sits out there that people have in some way simply forgotten. It's as though legal positivism and legal liberalism made this sharp break with the past and have tried to erase or forget the classical legal heritage. But it's extremely enriching, both personally and legally, to go back and read older sources.
Okay, excellent. So that brings us to the end of another insightful episode of Cátedra Jurídica. I want to extend my sincere thanks to Professor Adrian Vermeil for sharing his invaluable perspectives on common good constitutionalism and the classical legal tradition. This conversation has given us much to reflect on, especially regarding the role of law in advancing the common good and the ways in which legal theory can be enriched both in the United States and abroad. As always, we aim to bring you engaging discussions with leading thinkers that challenge the status quo and inspire deeper thoughts about the role of law and society. I hope today's episode has been both enlightening and thought provoking. Thank you to our listeners for joining us. Don't forget to subscribe to Cátedra Jurídica and stay tuned for our upcoming episodes, where we will continue to explore critical legal questions with distinguishing guests. Until next time, I'm André Oliano, and this is Cátedra Jurídica presented by Gazeta, Gazeta do Povo newspaper. Professor Vermeil, thanks again. It has been such a pleasure.
Thank you, Andre, for your excellent questions and discussion. Good to see you.